Thank you for joining. This is News Now Wyoming. Today we are going to be talking about the recent Supreme Court decision back in November of Taylor versus Riojas, the prison guards. This is the case that everybody's saying tears away qualified immunity, and qualified immunity no longer exists. We're going to look to see, does it really do that? Does it do as much as people think it does? Or does it just change it a little bit? So first, before we could talk about this latest case here in that came out in 2020, let's look at a few of the cases from 2020 that were denied the Supreme Court from hearing about them. This happened in June of 2020. The only thing that happened since then is Ginsburg passed away, who was very much against qualified immunity as a principle, and Barrett came onto the court. So, is that enough of a change? Somebody who was already against qualified immunity dying and being replaced by somebody else? Is that enough of a change to really change the world and the doctrine? So what did they actually turn away? So let's just look at this article really quick. After months of pondering, the court made this the doctrine that protects road police from federal lawsuits. The justices announced on Monday the court will not hear any of a raft of qualified immunity cases. Ended up being 9 cases that were denied. Only one justice, Clarence Thomas, signaled he disagreed with the decision not to reconsider qualified immunity. So it takes 4 people on the court to hear a case. 4 people. 5 people to change it, 4 people to hear it. So qualified immunity, briefly explained, we're going to ignore this. It is a principle created by the Supreme Court. It is not codified in law, and it's been in place since 1982. And it's only changed a little bit. So let's look at West versus Winfield, one of the several cases the court turned aside on Monday. They approached her saying that they believed her ex-boyfriend, who had an outstanding arrest warrant, was inside her home. After West gave an officer the key to her door and permission for the cops to enter her home, a SWAT team smashed several of her windows, punched holes in her walls and ceilings, and fired so much tear gas into the home that West could not live in it for 2 months. Yet they were entitled to qualified immunity. This is in June of 2020 that this case was denied the right for or the Supreme Court to look at it. This behavior is not egregious enough for the police or for the Supreme Court to say, you know what, maybe we were wrong. A woman says, yep, you can go in there and look, and they just completely destroy her home to where she can't go into it, live in it for 2 months. That's not egregious enough. What about another case? Baxter versus Bracey. So in this case, a defendant is a burglar, and he does not deny this, and they caught him breaking into a home. And as he's running away, he realizes he's caught, so he lays down on the ground and he surrenders. Okay, he surrenders. He's laying on the ground and he surrenders. That fact is not in question. Then the cops released their dogs to attack him, and they tore him apart. A lot of injury after he surrendered. And they were given qualified immunity because it was not clearly established at the time that a dog tearing up a suspect who has given up was clearly established at the time that it was bad. They did find that it was bad, but not that it was clearly established at the time. And that is not clearly established. So, and in 2020, this was decided just 6 months before the other decision that we're going to be talking about today was decided. That was not egregious enough to fall into the doctrine that they came up with here in this case we're going to be discussing. So, a suspect can be torn up after he surrenders by a police dog, and that's not egregious enough to fall into this doctrine. So, what do we actually talk about here in Riojas? and Taylor. So petitioner Trent Taylor is an inmate in the custody of Texas DOC. Taylor alleges that for 6 full days in September 2013, correctional officers confined him in a pair of shockingly unsanitary cells. The first cell was covered nearly floor to ceiling in massive amounts of feces all over the floor, the ceiling, the window, the walls, and even packed inside the water faucet. So nasty. Nobody should ever have to live in filth like that. And certainly not at the direction of the government. Fearing that his food and water would be contaminated, he did not eat or drink for nearly 4 days. Then the officers moved Taylor to a second frigidly cold cell, which was equipped with only a clogged drain in the floor to dispose of bodily waste. He held his bladder for over 24 hours, but he eventually and involuntarily relieved himself, causing the drain to overflow and raw sewage to spill across the floor. Don't try picturing this, you guys. This is disgusting. Again, nobody, I don't care what they were in prison for, nobody deserves this. The Court of Appeals for the Fifth Circuit properly held that such conditions of confinement violate the Eighth Amendment's prohibition on cruel and unusual punishment, but based on its assessment that the law wasn't clearly established that prisoners couldn't be housed in cells teeming with human waste for only 6 days. The court concluded the prison officials responsible for Taylor's confinement did not have fair warning that their specific acts were unconstitutional. So the appeals court says, yeah, no, this was bad. You shouldn't have done this, but it was not clearly established at the time that you shouldn't do this. The Fifth Circuit erred in granting officers qualified immunity on this basis. Qualified immunity shields an officer from suit when she makes a decision that, even if constitutionally deficient, reasonably misapprehends the law governing the circumstances she confronted. But no reasonable correctional officer could have concluded that, under the extreme circumstances of this case, it was constitutionally permissible to house Taylor in such deplorable, unsanitary conditions for such an extended period of time. See Hope. Fifth Circuit identified no evidence that conditions of Taylor's confinement were compelled by necessity or exigency. So in other words, there were other cells they could have put this prisoner in, but they didn't. They put him in these 2 cells that were completely filthy. This is a rare case, something that I hope never to see this type of thing again. Nor does the summary judgment record reveal any reason to suspect that the conditions of Taylor's confinement could not have been mitigated either in degree or duration. And although an officer-by-officer analysis will be necessary on remand, the record suggests that at least some officers involved in Taylor's ordeal were deliberately indifferent to the conditions of his cell. One officer, upon placing Taylor in the first feces-covered cell, remarked to another that Taylor was going to have a long weekend. So they thought this was funny. This was a joke to them. So clearly they knew it was wrong, is what they're saying. Okay. And another officer, upon placing Taylor in the second cell, told Taylor he hoped he would effing freeze. Confronted with the particular egregious facts of this case, any reasonable officer should have realized that Taylor's conditions of confinement offended the Constitution. We therefore grant Taylor's petition for a writ to vacate the judgment of the Court of Appeals for the Fifth Circuit and remand the case for further proceedings consistent with this opinion. Justice Barrett took no part in consideration, so one of the 2 new changes had nothing to do with this, and Justice Thomas dissents. So, Alito concurring to the judgment. Because the court has granted the petition for a writ to assert, I will address the question the court has chosen to decide. But I find it hard to understand why the court has seen fit to grant review and address that question. To see why this question is ill-suited for review, it is important to review the procedural posture of this case. Petitioner, an inmate in Texas prison, sued multiple prison officers and asserted a variety of claims, including both the Eighth Amendment claim that the court addresses and a related Eighth Amendment claim refusing to take him to a toilet. The district court granted summary judgment for the defendant on all but one of petitioner's claims under 54B, but which permitted petitioner to appeal the dismissed claims. On appeal, the Fifth Circuit affirmed as to all the claims at issue except the toilet access claim. On the claim concerning the conditions of petitioner's cells, the court held that the facts alleged in petitioner's verified complaint were sufficient to demonstrate an Eighth Amendment violation, but it found that the officers were entitled to qualified immunity based primarily on a statement in Hutto. The court now reverses the affirmance of summary judgment on the cell conditions claim. Viewing the evidence in the summary judgment record in the light most favorable to the petitioner, the court holds that a reasonable corrections officer would have known that it was unconstitutional to confine petitioner under the conditions alleged. That question, which turns entirely on an interpretation of the record in one particular case, is a quintessential essential of the kind we almost never review. So what Alito is saying here with this opinion is this is a one-off case, and we rarely ever look at this. The details in this case were so egregious that yes, they were bad here, but it doesn't overturn anything else that we've decided in the past. So that's how Alito is taking today's this November decision. Instead, we have well-known criteria for granting review, and they are not met here. So he's saying we should not have even heard this case. But since we did, yes, it's correct that. And then here, today's decision does not even conclusively resolve the issue of qualified immunity on the cell conditions claim because respondents are free to renew that defense at trial. And if the facts petitioner alleged are not ultimately established, the defense could still succeed. Indeed, if petitioner cannot prove the facts he alleges, he may not be able to show that his constitutional rights were violated. So what he's saying here is the guy can still lose this case if he cannot prove that the cells were in the condition that he talks about in his lawsuit. They're saying that on appeal, they are taking the facts in his favor, but in trial, he's got to prove it. So did anybody get in there with cameras to take pictures of these cells? I don't know the answer to that, but he may still lose this lawsuit if they didn't get evidence of the horrible conditions of the cell. While I would not grant review on the question of the court addresses, I agree that the summary judgment should not have been awarded on the issue of qualified immunity. We must view the summary judgment record in the light most favorable to the petitioner, and when petitioner's verified complaint is read in this way, a reasonable fact finder could infer not just that the conditions in the cells in question were horrific, but that respondents chose to place and keep him in those particular cells, made no effort to have the cells cleaned, and did not explore the possibility of assignments to cells with better conditions. A reasonable corrections officer would have known that this course of conduct was unconstitutional. The cases on which respondents rely do not show otherwise. So, Alito is saying here once again, this is not a one case fits all. This case is so egregious, so narrow focused, that yes, his rights were violated, and that a reasonable person would know that this is bad. This does not even change what qualified immunity is or does or says. This doesn't change anything about qualified immunity except in this one specific case. Again, let's look at those other two cases there that they decided not to hear. One case was a suspect surrenders. He's on the ground, and there's no question that he surrendered. And then he was attacked by police dogs. And that didn't qualify because it wasn't clearly established. And then the Supreme Court didn't hear that case. So don't tell me that this Taylor case, changes anything, because it doesn't. This changes nothing with qualified immunity except on egregious cases. And we're talking to the extreme of cases. Not just a little bit, maybe they cross the line a little bit. No, they have to cross the line a lot in order to fall into this new premise. I doubt most courts will even hear the argument or accept the argument as true for most cases. So this case does absolutely nothing for qualified immunity. So please, you guys, stop saying that this is the end-all be-all for qualified immunity. It does not do that. It doesn't come anywhere near that. Now, I wish it did. I wish the Supreme Court would overturn their 1982 decision. I wish that they would say that, we created a law when we made this doctrine up. We created this doctrine out of thin air. But they haven't done that. Since 1982, they've had hundreds and hundreds of cases where they could have done that, and they have refused to do so. And just this past year, 6 months before this very decision, they refused to hear cases that were, in my opinion, were pretty horrible. Not as horrible as this one. This case is probably the most horrible treatment of a prisoner I've heard of since the 60s. So, this is a specific case. Very, very horrible case. So thank you guys for joining. Let me know what you think in the comments below. Have a great day.